Let's just take a second to appreciate the absolute absurdity of the political timeline we are living in right now. Because if I told you 5 years ago that Ro Khanna, one of the most progressive members of the House, and Thomas Massie, a man who essentially wants to dismantle the federal government brick by brick, were teaming up to corner a Republican Attorney General over a sex trafficking cover-up, you would have told me to check my medication. But that is exactly where we are. This isn't a drill. This isn't a conspiracy theory on a message board. This is a formal bicameral demand sent straight to the desk of Attorney General Pam Bondi. And the message is loud, it is bipartisan, and it is incredibly specific. We know what you're doing, and we are not going to let you get away with it. Here is the situation. We are staring down the barrel of a statutory deadline. The Epstein Files Transparency Act wasn't just some toothless resolution. It was a law, passed overwhelmingly, signed into effect on November 19th. It gave the Department of Justice 30 days to hand over the keys. Everything. The unclassified records, the travel logs, the internal communications about why this monster was allowed to operate for so long. And now, with the clock ticking down to zero, 5 members of Congress have looked at the silence coming out of the DOJ and hit the panic button. They have demanded a briefing by Friday. Not next week, not after the holidays, Friday. And you have to ask yourself, why? Why the urgency? Why does a bipartisan coalition feel the need to haul the Attorney General into a briefing room mere weeks before the files are supposed to be public anyway? The answer is obvious, even if they're too polite to say it in a press release. They think the fix is in.
They are terrified that right now, as we speak, there are lawyers in the bowels of the Justice Department working overtime with black markers, redacting names, hiding connections, inciting procedural hurdles to make sure that the most damaging information never sees the light of day. The lawmakers explicitly flagged new evidence and procedural hurdles in their letter. That is Washington code for, we know you found something and we know you're trying to figure out how to bury it. And honestly, it is infuriating that we even have to have this conversation. We were promised, explicitly promised, that this administration was going to tear down the veil of secrecy. We were told that the deep state was done protecting its own. Yet, the moment there is a legal mandate to expose the network of a man who trafficked children to the global elite, suddenly we need briefings. Suddenly we need status updates. Suddenly, transparency seems to be moving at the speed of government bureaucracy. The law explicitly says, and I want you to really hear this, that the government cannot withhold documents to prevent embarrassment or due to political sensitivity. The fact that Congress had to write that into the law is damning enough. It's an admission that the DOJ usually protects powerful people from embarrassment. But the fact that they are demanding a check-in right now suggests they believe AG Bondi is about to ignore that clause entirely. This isn't just about Jeffrey Epstein anymore. This is about whether the executive branch follows the law, or whether they think they are above it. And when you actually dig into the text of what these senators and representatives are asking for, it becomes very clear that they aren't just looking for an update. They are looking for a confession. So let's actually look at the forensic evidence here. Because when you break down the timeline, the coincidences start to look a lot less like accidents and a lot more like a strategy.
We need to start with the text of the letter itself. This isn't a vague press release. Senators Merkley and Murkowski, along with Representatives Massie and Khanna, are specifically asking about procedural hurdles and new evidence. Now, why would they use those specific words? Because they know how the game is played. They know that in the world of the Department of Justice, new evidence is the magic wand you wave to make transparency disappear. Here's the mechanism they are terrified of, and it is buried right in the fine print of the Epstein Files Transparency Act. The law, Public Law 119.38, if you want to look it up, has 2 very important sections that are currently at war with each other. On one hand, you have Section 2B. This is the no BS clause. It explicitly states that no record can be withheld for political sensitivity, reputational harm, or embarrassment. That is the language that Massie and Khanna fought for. That is the language that is supposed to guarantee we see the names regardless of whether they have an R or a D next to them. But then you have Section 2C. Section 2C allows the Attorney General to withhold documents if they would jeopardize an active federal investigation. And wouldn't you know it, just days before this deadline, just as the pressure was mounting, the Trump administration suddenly announced a brand new investigation. And who is the target of this new investigation? Is it a broad look at everyone involved? No. President Trump specifically directed the DOJ to investigate Bill Clinton, Larry Summers, and Reid Hoffman. Do you see what just happened there?
By opening a new investigation into specific, high-profile Democrats right before the release deadline, the Department of Justice has potentially created the perfect legal shield. Now they can look at that pile of documents that might implicate people from both parties, and say, oh, we'd love to release these, really we would, but we have an active investigation now. Section 2.C says we have to keep these secret to protect the integrity of the case. This is why the lawmakers are panicking. This is why they demanded a briefing by Friday. They are watching the administration construct a loophole in real time. They are watching the active investigation exception being weaponized to override the political sensitivity prohibition. And let's look at the hypocrisy of this new investigation for a second. For months, Donald Trump called the Epstein Files a hoax. He said it was a distraction. He literally posted, "I don't care about the files." But now, suddenly, he cares enough to order a targeted probe? If the files are a hoax, what are you investigating? And if they aren't a hoax, why are you only investigating the people who opposed you in the last election? It is the definition of selective prosecution masquerading as justice. But it gets even more specific. The lawmaker's letter to Bondi explicitly mentions that any decision to withhold documents for an active investigation must be narrowly tailored. That is legal speak for you can't just slap a "do not open" sticker on the whole box because you're investigating one guy. They are preemptively calling out the strategy they know is coming. They are saying, if you're investigating Bill Clinton, fine, redact the sentence that jeopardizes that specific case, but do not use that investigation as an excuse to hide the flight logs that show who else was on that plane.
And let's be honest about what narrowly tailored usually looks like in Washington. It looks like a Sharpie marker running out of ink because it redacted 400 pages of a 401-page document. This is what Ro Khanna and Thomas Massie are fighting against. They aren't just fighting for a file dump. They are fighting against a bureaucratic magic trick where the Department of Justice uses a new investigation to bury an old crime. They know that if they don't get this briefing on Friday, if they don't force AG Bondi to look them in the eye and explain exactly what is being withheld and why, then on December 19th, we aren't going to get the Epstein Files. We are going to get a stack of black bars and a press release saying we cannot comment on ongoing investigations. And that brings us to the most disturbing part of this forensic deep dive, the timing. The law was signed on November 19th. The clock started ticking immediately. The DOJ has had these files for years. The FBI raided Epstein's home in 2019. They have had the hard drives. They have had the little black book. They have had the safe contents. The idea that they suddenly found new evidence or procedural hurdles in the last 3 weeks is insulting to our intelligence. They aren't finding new evidence. They're finding new excuses. The lawmakers know it. That is why the tone of this letter isn't inquisitive, it is adversarial. They are treating the Department of Justice not as a partner in transparency, but as a hostile witness that needs to be deposed. And if you think this is just about one bad actor or one administration, you are missing the forest for the trees. Because when you zoom out, you realize that this specific delay is just the latest chapter in a decades-long pattern of the Department of Justice doing everything in its power to make sure the full story of Jeffrey Epstein never ever sees the light of day.
And here is the reality that the Department of Justice absolutely does not want you to focus on. This behavior is not new. It is the default setting. If you zoom out, If you stop looking at this as a Pam Bondi problem and start looking at it as a DOJ problem, you realize that for nearly 2 decades, the Department of Justice has operated less like a law enforcement agency and more like a private security firm for Jeffrey Epstein's Rolodex. It is not a conspiracy theory. It is a documented historical record. Let's go back to the original sin of this entire saga, the 2008 plea deal. This wasn't just a sweetheart deal, it was a legal abomination. Alexander Acosta, who was the U.S. attorney at the time, and who, let's not forget, was later appointed labor secretary by Donald Trump, signed off on a non-prosecution agreement. But it wasn't just for Epstein. Buried in that agreement was a clause that granted immunity to any and all potential co-conspirators. Think about that for a second. The federal government, ostensibly the most powerful law enforcement body on earth, looked at a man trafficking children to billionaires and royals, and instead of prosecuting him to the fullest extent of the law, they signed a contract that effectively said, "We promise never to look at your friends." Why? Why would a U.S. attorney do that? Well, we don't have to guess, because Acosta reportedly told the Trump transition team exactly why. He allegedly said that he was told to back off because Epstein belonged to intelligence and that the case was above his pay grade. He belonged to intelligence.
That isn't a quote from a Reddit thread. That is the former U.S. attorney explaining why he let a monster walk free. And if that is true, if Epstein was an asset, a source, or a protected figure for any intelligence agency, then suddenly the DOJ's behavior for the last 15 years makes perfect sense. They aren't hiding sex crimes. They are hiding sources and methods. They are protecting the national security implications of admitting that the U.S. government or its allies allowed a pedophile ring to operate because it was useful for blackmail. This is the context you need to understand why Pam Bondi is stalling. She isn't inventing these tactics. She's inheriting the playbook. And look at what happened in 2019. Jeffrey Epstein is finally back in custody. He's in the Metropolitan Correctional Facility, one of the most secure facilities in the United States. He's the single most high-value prisoner in the country, possessing information that could topple governments. And what happens? The cameras malfunction. We are expected to believe with a straight face that in a federal facility designed to hold terrorists and drug lords, the cameras outside Epstein's cell just happened to suffer a technical glitch at the exact moment he died. We are expected to believe that the guards just fell asleep. We are expected to believe that he was taken off suicide watch mere days before his death. It is insulting. The Department of Justice's own Inspector General report found negligence, misconduct, and falsified logs, but they concluded there was no foul play. They want you to believe it was just a perfect storm of incompetence. But here is the rule of thumb for Washington. Incompetence is rarely this precise. When the cameras break only for the guy who knows where the bodies are buried, that isn't a glitch, that is a feature. And this pattern of convenient failures continued right into the Ghislaine Maxwell trial. Did you notice how that trial was handled? The DOJ successfully prosecuted Maxwell, yes, but they did it in the most surgically precise way possible. They focused entirely on her interactions with the victims. They barely mentioned the men. The little black book was effectively kept out of the spotlight. The clients, the men who paid for the abuse, the men who flew on the planes, were treated like ghosts. Even recently, Judge Paul Engelmeyer ruled against unsealing grand jury transcripts related to Maxwell, stating that they would reveal next to nothing new and suggesting that the government's push for transparency was actually a diversion. Do you see the pattern yet? Every single time we get close to the truth, the Department of Justice steps in to manage the fallout. In 2008, it was a non-prosecution agreement to protect the co-conspirators. In 2019, it was a camera malfunction that closed the case on Epstein himself. In 2021, it was a trial strategy that ignored the clients. And now, in 2025, just as a law forces them to release the documents, they suddenly announce a new investigation and cite procedural hurdles.
It is the same strategy, recycled over and over again, regardless of who is in the White House. Bush's DOJ protected him. Obama's DOJ didn't reopen the case. Trump's DOJ oversaw his death. And now the new Trump administration is stalling the release. This is bipartisan corruption at its absolute finest. It is the one thing that unites the political establishment, the desperate need to keep the lid on this specific jar. And that is why Massie and Khanna are so dangerous to them right now. You have a progressive who wants to expose the corruption of the wealthy elite and a libertarian who wants to expose the corruption of the federal surveillance state. They are attacking the DOJ from both sides, squeezing AG Bondi in a pincer movement that she cannot easily escape.
They know that the intelligence excuse is coming. They know the active investigation excuse is coming. They have seen the broken cameras and the sweetheart deals, and they are saying, not this time. But here's the terrifying part. If the DOJ succeeds, if they manage to use this new investigation into Clinton and Summers to redact the rest of the list, then they have effectively created a blueprint for permanent secrecy. They will have established that the government can simply open a fake investigation any time a deadline approaches, forever keeping the truth just out of reach. So, where does this leave us? What is actually at stake here? Because if you think this is just about getting a peek at a sorted list of names so we can post memes on Twitter, you are missing the terrifying reality of the endgame. If the Department of Justice is allowed to defy the Epstein Files Transparency Act, a law that was specifically written to strip them of their usual excuses, then we have effectively crossed a Rubicon in this country from a republic of laws to a managed oligarchy. Think about the precedent that is being set right now, in real time. Congress passed a law. They included specific language prohibiting redactions based on political sensitivity. They included specific language demanding narrowly tailored exceptions. And if Attorney General Bondi walks into that briefing on Friday, or worse, refuses to walk in at all and says, "We aren't doing it because of an active investigation into Bill Clinton," then Congress has just been rendered obsolete. It means that the executive branch has discovered the ultimate cheat code. It means that any administration, Republican or Democrat, can hide any crime, any corruption, and any incompetence simply by opening a fake investigation the week before the deadline. It renders the concept of oversight completely dead.
But there is a darker strategy at play here, one that we need to inoculate ourselves against immediately. In the intelligence world, there is a term called a limited hangout. A limited hangout is when an agency is caught doing something wrong, so they voluntarily release some of the incriminating information, usually the stuff that is already rumored or the stuff that damages their political enemies, in order to satisfy the public's hunger for truth while keeping the truly damaging secrets locked away forever. That is exactly what we are seeing with this sudden announcement of an investigation into Clinton and Summers. They are preparing to give you a scalp. They are going to throw Bill Clinton to the wolves. They might throw Larry Summers or Reid Hoffman under the bus, and they are hoping that you will be so satisfied watching those specific figures fall, you will be so busy cheering for the demise of your political opponents that you will forget to ask about the other 90% of the names on that list. They are counting on your partisanship to blind you. They want the narrative to be Trump DOJ investigates Clinton. They do not want the narrative to be DOJ releases files implicating the entire global financial and political establishment. Do not fall for the shiny object. If the files released on December 19th only contain the names of Democrats, it is a lie. If the files only contain the names of people who are already dead, it is a cover-up. Jeffrey Epstein didn't just traffic children to one political party. He didn't just operate in one social circle. He was an equal opportunity corrupter. He ensnared scientists, academics, royals, bankers, and politicians from every corner of the globe. If the transparency we get is one-sided, it
isn't transparency. It is a weapon, and it is the most cynical kind of weapon because it uses the suffering of children as political ammunition while protecting the system that allowed that suffering to happen.
And let's talk about that system. Let's talk about the erosion of trust that is happening right now. If we cannot get the truth about Jeffrey Epstein, the most obvious, documented, and egregious case of elite criminal impunity in our lifetimes, then how can you trust the Department of Justice on anything else? How can you trust them when they tell you a bank fraud case was too difficult to prosecute? How can you trust them when they say a drone strike killed militants and not civilians? How can you trust them when they say they are protecting your data, your elections, or your rights? If they can look at a pile of evidence showing that billionaires raped children and say, sorry, this is too politically sensitive to release, then the Department of Justice is no longer a law enforcement agency. It is a protection racket. And honestly, it is pathetic that we have to frame it this way, but we have to talk about the survivors. In all the political maneuvering and all the letters between congressmen and attorneys generals, the actual human beings at the center of this, the women who were stolen, abused, and silenced, are being victimized all over again. The Epstein Files Transparency Act had a specific provision to protect survivors. It was supposed to center them. But what we are seeing is the Department of Justice using the concept of victim protection as a shield for the perpetrators. They will tell you they are redacting names to protect privacy. But whose privacy? Are they protecting the privacy of a victim who has been screaming for justice for 20 years? Are they protecting the privacy of a hedge fund manager who doesn't want his wife to know he was on the flight manifest? Every day that these files are withheld is another day that the victims are told their abuse matters less than a powerful man's reputation.
That is the moral rot at the core of this delay. It is the message that in America there are two systems of justice. There is one for you and me, where if you break the law, if you steal a car, if you possess drugs, the full weight of the state comes down on you instantly. The cameras don't break, the guards don't fall asleep, the files aren't redacted. And then there is the system for them. The system where procedural hurdles suddenly appear. The system where non-prosecution agreements are signed in secret. The system where political sensitivity is a valid legal defense for hiding a felony. Representatives Massie and Khanna and Senators Merkley and Murkowski are trying to bridge that gap. They are trying to force the elite system to play by the peasant rules for once. And that is why the establishment is panicking. That is why they are scrambling for loopholes. Because if the full truth comes out, not the sanitized, limited hangout version, but the full truth, it doesn't just destroy a few careers, it delegitimizes the entire structure of power in Washington. It reveals that the people running the world were compromised by a man who made his living trafficking human beings. So Friday is the test. Friday, December 5th, is not just a deadline for a briefing, it is a litmus test for the new administration and for the rule of law. If AG Bondi shows up and lays it all on the table, if she says, here is everything, we aren't protecting anyone, let the chips fall where they may, then maybe, just maybe, there is hope for institutional accountability. But if she stalls, if she hides behind active investigations, if she claims executive privilege or national security, then we know. We know that the deep state isn't some abstract boogeyman. It is the concrete reality of a government that protects its own sins at all costs. We know that the new DOJ is just the old DOJ with a fresh coat of paint. And we know that the Epstein Files Transparency Act has been murdered in its crib. We need to be loud about this. We cannot let the news cycle move on. We cannot let them distract us with the next outrage or the next manufactured controversy. The media will try to pivot. They will try to talk about the economy or a foreign conflict or a celebrity scandal. Do not let them. Keep your eyes on the deadline. Keep your eyes on the redactions. Demand to know why a law passed by 427 members of the House is being treated like a suggestion. Because if we lose this, if we let them bury the Epstein files again, we are not just losing a document, we are losing the right to call ourselves a free society. A free society does not have secret laws.
A free society does not have secret courts, and a free society certainly does not have a secret list of elites who are allowed to abuse children with impunity. The clock is ticking. The letter has been sent. The demand has been made. Attorney General Bondi, the ball is in your court. But know this, we are watching. Congress is watching. And this time, we're not going to accept the cameras broke as an answer. Let's see what happens on Friday. But until then, stay angry, stay vigilant, and do not let them gaslight you into silence.